Hello, my name is Arab Samsekesi. Today I'll be doing a case-based analysis of a real-life scenario that is becoming more rampant. It is a scenario of whistleblowing versus data protection, a legal and ethical analysis of today's case as a cybersecurity consultant. The context and facts of the incidents are here. An employee has leaked sensitive customer records to a third party, alleging corporate malpractice. The employee claims that the organization is defaming him and they are in the wrong, and he is doing this. He is whistleblowing as he has interest of public, but the organization stance on this case is very clear. The company asserts violation of data protection laws, international policies, breaches, and confidentiality agreements. This case matters because it is a high stake cases of customer trust, legal exposure, the damage of these kind of things is very impactful, and this case potentially breaches many laws like GDPR, Data Protection Act 2018, and other contractual confidentiality obligation. And it also has ethical complexities of whistleblowing motives and unlawful disclosure. The line between what is right and what is wrong can be a very slim line, and this case highlights it very much. So now let's go into the legal analysis of this of the case. The key legal instrument relevant to these cases are the GDPR. This is the principle of lawfulness and purpose limitation and data minimization based on processing. The UK's Data Protection Act 2018, it is the domestic implementation of the GDPR, and improvisation of the GDPR. And also many of the contract laws, the confidentiality laws which an organization signs with its employees, and also cross-border data transfer rules, because this is a international organization. The cross-border data transfer rules also uh, apply to this case. To the legal analysis of the case, the key legal instruments relevant to these cases are as follows. The GDPR, the General Data Protection Regulation, is a highly relevant key legal instrument that is built upon the principles of lawfulness, purpose limitation, and data minimization, and uh, any disclosure of personal data without lawful biases is that you are in a breach. And all again, and another key legal instrument is the UK's Data Protection Act 2018. It is the domestic implementation of GDPR, and it has its own provisions. And we must also consider the Computer Misuse Act of 1990. It states that the unauthorized access of a data and intentional data exploitation beyond the scope of an employee is not a case of civil breach but a criminal charge. And other contract laws like confidentiality clauses and employment contracts, and also cross-border data transfer rules also apply to this case because it is an international company. These rules also apply. Now applying data protection law to the leaks, uh, three questions rises. Was processing lawful? GDPR Article 6 requires a lawful basis while handling customers' data. Disclosing personal sensitive data to a third party. usually violates this provision without any mention of the employee's intent. Second one, are there any special categories of sensitive data that are being leaked? If there are, then the chances of stricter punishments and criminal increment happening to you is very high. And third, the harm that is caused to the customers that is often overlooked in this subject. The breach of confidentiality can cause irreparable harm to the customers and triggers breach notification obligation under 72 hours. So from a data protection point of view, the employees actions probably constitute the violation of these provisions, irrespective of their motivations. Now for the whistleblowing protections, its scopes and limits. The UK's Public Interest Disclosure Act protects disclosures that reveals wrongdoings in the public interest, but protections usually typically requires following an strict internal external reporting through channels like regulators, and if any disclosures are done without following the proper guidelines, the Public Interest Disclosure Act may not apply to it. The illegality versus unlawful disclosures. The protection does not automatically cover unlawful processing of personal data. Courts weigh proportionality and means of disclosure. How you disclose the wrongdoings and how much it impacts the public also is being weighed. So it is very important to know this for the whistleblowing protections for its scopes and limits. To the ethical analysis of the case, for this case, I want to apply the two ethical frameworks that we have here. First is the utilitarian view, and from the utilitarian view, we can ask that if the whistleblowing had actually benefited the larger public at hand, and did and without compromising the public trust too much. But on the other hand, looking this case at the utilitarian view, we can also see that the employee that tried to help the public by exposing the corporate wrongdoings uh, also in the process harmed the public they sought to protect. From the deontological point of view, we can see that this case becomes more clearer, and from the deontological point of view, the employee disregarded rules and regulations and did not follow any rules and did not oblige to any laws. And professional responsibility as a cybersecurity professional, professional, we must find the balance between confidentiality and public interest. These are the things that needs to be held at the highest regard, and it needs to have a balance for the best results. Now, by balancing the ethical and legal analysis, we can assess the case into three parts. What's the harm? What's the benefit? Was there any how much was the benefit of disclosing personal data to a third party? How much benefit was there in whistleblowing? And the second thing is where the legal rules and channels followed throughout the whistleblowing, and proportionality, was the uh, harm smaller or larger than the benefit. These things needs to be addressed, and we need to look at this at the whole way. And looking at the case, I think the employee falls short on their promise of bringing benefit. I think they bring more harm than benefit. So now where does this leave the organization? I think the organization needs to take some of these recommendations to ensure these threats are not will not happen in the future, or may at the very least the damage will be very low. First and foremost, we need to strengthen policy and incident handling. Clear whistleblowing channels needs to be created. Defined escalations and strict data handling protocols needs to be in place. And least things like least privilege and logging needs to be implemented. Training and ethical awareness. Regular training on on privacy law, ethical decision making, and safe whistleblowing procedures tailors to the roles. These things needs to be given to the employees. Then they need the organization needs its employees to know about how they can create a perfect ethical decision, and how the safe whistleblowing procedures should be handled. Governance oversight needs to be the governance oversight needs to be done. We need to create an independent compliance oversight, rapid breach response playbooks, and periodic audits of whistleblowing effectiveness. How much uh, overseance and how much oversight is happening can directly result in declining of external threats. We need to technical the cyber side of the story. We need technical controls like data loss preventions, DLP, privileged access management. Only the person who has privilege of accessing any data at a certainable time should access the data. And we need robust encryptions, end-to-end encryptions. Now for the conclusions, I think the employee may have ethically motivated reasons, but likely violated data protections and computer misuse rules if they disclose personal data unlawfully. Organizational response should combine legal review with remedial governance and support legitimate whistleblowing channels. You need to support the legitimate whistleblowings, but in I think in this scenario the employee as is in the fault. And there are few key takeaways from this. One was the whistleblowing protections are constrained when personal data is disclosed improperly. The second one is proportionality and prior reporting are central to the protection claims. And third one is prevention requires both technical controls and ethical governance. Thank you for your time, and this is